Good afternoon. This video is the lecture for America's Courts, Chapter 11. Um, if you recall in the last lecture, Chapter 10, we discussed what crime was, specifically how crime is measured, and then we started going through the actual courtroom process from arrest all the way through the preliminary hearing slash grand jury. So in this lecture, we're going to be discussing evidence, specifically discovery and disclosure of evidence and case law surrounding those processes. Again, if you are watching this video, you're in my Crim 4 class for Madera Community College. I would recommend that you print out the PowerPoint for Chapter 11 and go along, because the lecture is basically an overview of the PowerPoint, and that way you can kind of highlight those areas and then write your notes in the margin, which will help you for the test for this module, and I believe that is chapters 8 through 11. So we will get started. The first slide is discovery. Prosecution and defense engage in a practice called discovery, and essentially what discovery is, it's a process that is designed to prevent one side from having an unfair advantage over another one. And discovery is a pretrial procedure where the prosecution and defense exchange information such as testimony, records, and other evidence with each other. So the Supreme Court's already ruled in this under Weatherford v. Versey in 1977. They determined that the Constitution does not give a right to discovery in a criminal case. However, subsequent court decisions, statutes, which is legislative law, and court rules have provided the framework for criminal discovery process. So the process of discovery is different from state to state. Most of the states allow for limited discovery of evidence, such as the defendant's confession and physical evidence. So again, those would be the transfer of information between the prosecution and defense. All right, so there's different types of evidence, and these two you will likely see again. Exculpatory is evidence that may be favorable to the defendant at the trial, either by casting doubt on the prosecution's case or mitigating the defendant's culpability in a crime. So that exculpatory evidence essentially is evidence of an excuse, or it basically takes away the defendant's culpability of that crime, or presents casts doubt on the evidence that the prosecution is submitting to prove their case. Impeachment evidence is evidence that would cast doubt on the credibility of a witness. So that would be specific evidence. And an example to that would be if you were a prosecutor and you brought up one of the gang members who was testifying against another gang member. Impeachment evidence would be evidence that you would use the fact that that person is a gang member and they're in a gang, or they're in an opposing gang with the person that you're defending. You can impeach that person's character based on the fact that they are in a gang and are less likely to be truthful and forthcoming with information. So that would be considered impeachment evidence. Under Jenks v. United States, and this is one of the first court cases that actually addresses the idea of discovery, the Supreme Court decided that prosecution must disclose any prior inconsistent statements across prosecutorial witnesses so that the defense can conduct a meaningful cross-examination. So what that essentially means is that it was required that the prosecution has to disclose any of the statements that the prosecution collects from its witnesses that may be in conflict with another statement that they provided previously. So if information was gathered from one of the witnesses who the prosecution is going to use, gives testimony shortly after the incident, and then later on recants or gives a different testimony, that information has to be given to the defense. Now, here's the caveat to that. Jenks also ruled, well, not they didn't rule. There was another finding after the fact that it isn't an automatic transfer. It's much like Brady is. So, and we'll get to Brady in a second. What it requires is that the defense request that information. So it didn't make it automatic. Unlike in Brady, next line is Brady comes from the Supreme Court ruling in Brady v. Maryland, where the court determined that exculpatory evidence that is suppressed by the prosecution violates due process, where the evidence is material to either guilt or punishment, irrespective of the good faith or bad faith of the prosecution. That information or that evidence has to be given directly to the prosecution, or rather the defense. Otherwise, and then exculpatory evidence is evidence that would be, again, we talked about that up there, evidence that may be favorable to the defendant and not necessarily the prosecution. It's required to be given. And if it doesn't, it violates due process, especially where evidence is material to either the guilt or punishment. So anything that would remove a level of guilt to the person who's being the defendant, and or the type of punishment that person, the sentence that they're going to get. So those are the two areas. Those are the two biggest landmark rulings. Jenks v. United States, you'll likely see that again. And then Brady v. Maryland, you'll likely see that again as well. You'll probably see other court case areas that you might need to be cognizant of. You'll need to see, I want to say it's United States v. Darton, and we'll get to that one in a bit, and obviously Miranda v. Arizona. So those are some of the other ones that will wind up, you'll need to be aware of in specifically for this chapter. All right, moving on. Slide 2 talks about criminal discovery law, and again, Jenks v. United States, this is in your text, and then Brady v. Maryland, we went through that a few seconds ago. Take some time to read through that. It kind of gives a little bit more detailed information about those two cases. All right, and then here is more case law with regard to discovery. Williams v. Florida, United States v. Aguirre, Weatherford, Bursey, United States, Bagley. All of these are specific to discovery. All right, slide number 4. Informal, prosecutorial, and reciprocal disclosure. If you look at the importance of discovery, you'll know that while both sides benefit from discovery, both sides, if there's exchange of information, both sides benefit. The defense benefits more, and that's just by virtue of the fact that a defendant doesn't have to prove his innocence. He just has to cast doubt on the prosecution's case. So it's significantly easier to do that if the defendant and the defense knows what the prosecution's case is in the first place. Knowing what the state's case is against the defendant allows the defense attorney to carefully craft a case for their defense, and more specifically, not necessarily to defend the individual, but to cast doubt on the case of the prosecution. The idea behind informal prosecutorial disclosure is that an advanced view of the prosecution's case by the defense may encourage the defense to accept a plea deal because of the nature and strength of the prosecution's evidence. And so sometimes that does work to the benefit of the prosecution, essentially tipping your hand, saying this is what we got. There's not really much wiggle room. And you can see that, again, we talked about that with regard to plea bargaining. During the discovery portion, that's kind of where the plea bargaining really gets intense, because the defense, or rather the prosecution, provides this information and says, look, we've already got all this. We've got, A, B, C, D, all the way through Z. We have your guy dead rights. So they'll be less apt to want to accept a lenient plea bargain. And in all likelihood, if they do accept the plea bargain, it'll be something that is really, really not very far removed from the conviction and punishment that they're originally going for. Normally when they plea bargain, they'll give a little bit of something, but not generally a lot. And that, however, as the slide notes, this can sometimes backfire when the prosecution's case is weak, emboldening the defendant to take the case to trial if the prosecution doesn't have a substantial benefit to the plea bargain. And so sometimes it's beneficial. If the case is really weak, the defense can say, well, you know what, my client decides he wants to go to court, and we're going to go to court, and they'll start, and then the prosecution will be left making a decision as to whether or not they're going to accept a counter offer, or they're going to go to court and try to roll the dice and see if they get the case. So the idea of discovery is essentially a tipping of a hand to let them know what we're going to be using as evidence to support our case. Reciprocal disclosure is the automatic discovery for certain types of evidence without the necessity for motions and orders or court orders. You'll need to know that. The Constitution limits reciprocal discovery in criminal cases because the defendant has a right against self-incrimination, right? So the prosecution essentially is required to pretty much give all of the evidence that they have, the witnesses they're going to call, the physical evidence, all papers and effects. But with regard to the defense giving information to the prosecution, they have a lesser level where they have to. In some instances where the defendant has a duty to disclose information to the prosecution would be evidence in support of an alibi defense. So if there was a movie with Brad Pitt where Brad Pitt and three other young men were in a juvenile home, and for the life of me, I can't recall the movie. If some of you know what it is, go ahead and send me a text or email indicating you know what the name of this movie is. And anyway, when they're young, they get sent to a boys' home, and in that boys' home, they suffer at the hands of the correctional staff that are there sexual assaults. It damages their psyche. They live with this going up into young adults. Two of the young men grew up and got respectable jobs. One of them was working as a news reporter, and the other one was working as an attorney. The other two didn't do very well. They went into gangs and ultimately led a life of crime, to include murder. And an issue happens where the two young men older men who were in the gangs run across one of the guys. They come across and they recognize him when he's eating a meal, and they decide to kill him. And they did it there in cold blood in a restaurant. And of course, they were both arrested and they were charged with the murder. And there was an elaborate scheme with the friend who was a prosecuting attorney, a friend who was the news reporter, and some other people in that neighborhood to basically bring all these people who violated these people when they were younger to justice. And the idea, one of the witnesses was brought in, gave testimony that claimed that the two defendants who said that they were not, or two defendants who were there at the restaurant when they got shot, the one alibi witness said that they were not. They were with him at a basketball game. And that's essentially what an alibi defense is. And there's a little bit of latitude that is offered to those individuals, except for, like I said, in the case of alibi defenses. And that was an opportunity where the prosecution cross-examined. And in the movie, they basically verified that information. If some of you guys remember the name of the movie, email it to me, because for the life of me, it escapes me right now. And if you haven't watched it, once we get the name, I would highly, highly encourage watching it. It's a phenomenal movie, and it goes through the court process pretty well. So an alibi defense allows a defendant to produce evidence, either physical or testimonial, via a witness that claims a crime was committed while the defendant was somewhere else and could not have been the perpetrator. And in that movie, that's exactly what had happened. All right, slide 5, suppressing evidence. So the most controversial Supreme Court decisions regarding evidence comes from how the evidence is gathered by the police. And we've talked about that before. You will likely see that again. So the most controversial Supreme Court decisions regarding evidence comes from how the evidence is gathered. Multiple court rulings led to the exclusionary rule and the fruit of the poisonous tree doctrine. So you will see the exclusionary rule again. That was created by judicial decision, which holds that evidence obtained through violations of constitutional rights of the criminal defendant must be excluded from trial. Prior to Mapp v. Ohio, Supreme Court decision, the exclusionary rule was not applied in state court rulings. In the Mapp case, police conducted an illegal search of the home and secured evidence that led to a pornography conviction. Exclusionary rule also applies to pretrial confrontations, which is a process where the victim confronts the alleged perpetrator via a lineup or photo lineup for the purposes of identifying the suspect or the alleged suspect. Fruit of the poisonous tree doctrine is essentially what is gathered. So it's the evidence directly obtained as a result of a constitutional violation or an illegal search. Fruit is a derivative of the evidence obtained because of the knowledge gained from the first illegal search, arrest, confrontation, or interrogation. So there's four doctrines, that mitigate the use of illegally obtained evidence and fruits derived from illegality. So the first is good faith, which is the law enforcement acting on the warrant or law to be valid. So, and that kind of goes with regard to, police supplying the correct amount or the correct level of evidence for the judge to make to issue that warrant. So if the officer lies, perjures himself when he's giving that information, that warrant, in effect, does not have good faith. It's the same thing with, an officer getting a warrant and acting on that warrant, even though that warrant may not have met the standard of evidence, the probable cause standard when it was issued by the court. All right, so the second is an independent source doctrine, or is the independent source doctrine, which is evidence obtained for use at a trial that is independent, unconstitutional police action. Pretty much self-explanatory there. If law enforcement goes over what their color of authority allows for, that evidence, then it's not, their actions are not constitutional. That evidence is therefore tainted as well. Third is the inevitable discovery doctrine, which holds that the court may admit illegally obtained evidence if it would have been discovered anyway through independent lawful means. So the court does have some latitude with regard to if that evidence is going to be admitted, if they can prove that through a timeline that information would have been available had they went through and actually got a correct warrant, or as I said before, where the information, like say for instance there was a warrant for a search, Officer A submitted that information knowing it to be false, the warrant is issued, and then Officer B, who doesn't know anything that's going on, just knows that he has a warrant in his hand, executes that warrant and secures the evidence. So that evidence could in fact be used in the trial, because even though it was the warrant was requested inappropriately, the good faith of the officer who actually conducted the search allows it to be admitted. Fourth, the attenuation exception allows the court to admit evidence that is so far removed from the original constitutional violation that the influence is attenuated. And attenuation is essentially a weakened excuse, right? If you have an attenuated exception, that means that if it gets diluted, and again, going back to my original example, The reason why they can introduce that evidence, even though the original warrant was faulty by Officer A, when Officer B gets it, his good faith in the fact that the warrant is a valid warrant because it was issued by a judge, and he doesn't have any background information as to the investigatory process in which that warrant, that evidence was issued for that warrant, attenuates his responsibility or his liability with regard to that warrant itself. So those are the four doctrines. You'll definitely need to know that. You'll see them again in an upcoming exam. All right, moving on to number 6, interrogations and confessions. So the 6th and the 14th Amendment to the Constitution addresses interrogations conducted by the state. 6th Amendment notes, quote, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense." The 14th Amendment notes, "Nor shall any state deprive any person of life, liberty, or property without due process or law, nor deny any person within its jurisdiction equal protection of laws." So the 6th and 14th Amendments to the Constitution address interrogations by the state, and those interrogations are, when we're talking about the state, the first interrogations that generally happen are by police, and those are also governed by Supreme Court ruling. And again, you'll see this again, Miranda v. Arizona. So in order for a confession to be accepted as evidence at trial, it has to meet the voluntariness standard, which is the confession must be given free and voluntarily. In other words, not through coercion, not through promise or threats. It has to be given without any promises or threats by the state. In court decision Miranda v. Arizona in 1866, the court imposed upon law enforcement a requirement to advise the arrested person of their constitutional rights to remain silent, to be free from self-incrimination, that whatever they say can be used against them in the court of law, that they have a right to counsel during questioning even if they can't be afforded. Miranda finding is based on the 5th Amendment protection that notes that no person shall be compelled in any case to be a witness against himself. And this advisement led to the Miranda warning. So Miranda v. Arizona is not the Miranda warning. The advisement or the order is the Miranda warning. Following this ruling, the state now has the requirement to prove that they advise the defendant of their rights, and the defendant knowingly and voluntarily waived those rights prior to interrogation or confession. And generally this is done, the best way it's done is via writing and audio, video, CCTV video recording. But when they have body cams, a lot of this stuff is on body cams when they do give their rights and read the Miranda admonishment. And then again, it's not just giving the Miranda admonishment, but getting a knowing and voluntary waiver of the rights that are advised, that you're advising them of. So there are some exceptions to Miranda, such as law enforcement not required to Mirandize a person who is not in custody, or if they are in custody and after they Mirandize, they spontaneously provide incriminating statement. And that happens, believe it or not, a lot. So an officer will take a person into custody, following maybe a foot chase or something, and right when they get cuffed up, hey, I want to talk to you about this. I don't want to talk to you. I want my attorney. And say, okay. They give them the Miranda, and they're like, yeah, I don't want to talk to you. And then they'll put them in the car, and on the way over to booking, they'll start saying, well, I didn't do anything. And the officers normally won't say anything. They just start noting what this person is saying, and they'll provide this information of their own volition. They generally won't, they have essentially diarrhea of the mouth and start rattling on. So even though the Miranda warning was provided, and they elected to remain silent, anything they say following that, regardless of whether or not they say they're going to remain silent or not, is admissible if it was not solicited. So it had to have been spontaneously given. It could not have been requested information by the officer. All right. The next few pages are going to be pages within the textbook. They're specifically, most of them are court case findings, case law, key developments in interrogation law, so obviously derived from the 5th Amendment, and English common law, and again, all the case law surrounding interrogations. You should make yourself aware of those. And it keeps going on through the 9th page, which is, I believe it ends at Salinas v. Texas. All right, moving on to slide number 10. Search and seizure. Fourth Amendment to the United States Constitution notes that the right of the people to be secure in their persons, housing, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And that's pretty self-explanatory, and it is really, really kind of cut and dry. So it tells us a standard of evidence where a warrant can be requested and issued that has to be met, and no warrant will be issued until probable cause is found. That probable cause finding has to be supported by an oath or affirmation. That would be a swearing of a peace officer, and has to describe the place to be searched and the person or things to be seized. So it's very, very specific in the Fourth Amendment with regard to people's rights. Ensuring that searches are conducted by law enforcement are reasonable, a determination of what is unreasonable must be established. So an unreasonable search and seizure occurs when law enforcement infringes upon the property rights or the unreasonable expectation of privacy by conducting a search and or seizure without complying with the warrant clause, which is the second clause of the Fourth Amendment. So since if they don't do everything that's said in the Fourth Amendment with regard to the second clause of the Fourth Amendment, that is considered unreasonable search and seizure, and as a result, all the evidence that is secured in that will likely fall under the exclusionary rule / fruit of the poisonous tree. Typically, probable cause is necessary to conduct a search or seizure for evidence or to make an arrest. However, the Supreme Court has made some exceptions to this rule, such as, and you may see these again, stop and frisk, cursory protective sweeps, and exigent circumstances. Exigent circumstances are circumstances that would cause a reasonable person to determine that prompt action is required to protect a person, to prevent the destruction of evidence, or to prevent the escape of a subject. So a quick example of exigent circumstances: officer is, doesn't have a warrant. He observes a lot of hand-to-hand transactions occurring, or a lot of people driving up to this house, or people knocking on the door. He observes hand-to-hand transactions. They take off. It happens 2 or 3 days. As opposed to going and getting the warrant, and during one of those transactions, the person that's inside the house yanks the other person inside and closes the door. Officer hears screaming, goes in because of his or her belief that somebody is in imminent peril, goes in, finds the person getting beat up, conducts the arrest, and then, of course, they find a bunch of drug paraphernalia and drugs and packaging material and scales and everything else. All of that would be considered prompt action as a result of exigent circumstances of that arrest. Okay. Slide 11, specific to search warrants. A search warrant is a written order by the court directing law enforcement to search personal property, and if found, to bring it before the court. The Fourth Amendment search warrant must describe the place to be searched and the person or things to be seized. So when a police officer decides a search warrant is necessary to secure evidence, an affidavit is provided to the court by the officer. And this affidavit is a written statement of facts sworn before the court. An affidavit submitted by a law enforcement official that has knowingly false information can result in criminal charges for the officer, and I talked about that earlier. That was perjury, civil liability for the officer and the department, and exclusion of the evidence if it's collected. So there could be some severe sanctions. In all likelihood, if it's found that the warrant was a tainted warrant, it was issued in bad faith, officer provided false information or gave false testimony, not only will he or she get charged with perjury, have some kind of civil liability, could have civil liability, the likelihood is they're going to lose their career and probably not be able to work in the field of law enforcement ever again. Given that law enforcement is a 24-hour, 7-day-a-week process, the need for search warrants also follows suit, and as such, judges are also available 24/7 to review warrant requests, and they generally will work off of a rotating schedule. So a judge may have a rotating schedule for 24 or 48 hours where they are the ones who receive the telephone calls at 2 o'clock at night, or rather 2 o'clock in the morning, indicating the need for a warrant. They do these telephone warrants. The warrant is received, and sometimes officers will actually go out and collect the signature from the judge for those warrants. Under the Fourth Amendment, search warrants must be specific in the area that is to be searched and the items to be seized, and we talked about that. And this is done so the officers executing the warrant can identify the items with reasonable certainty and are left with no discretion as to which property is to be taken, right? So, again, warrants have to be pretty specific because you don't just get free reign of the property unless the warrant specifically spells that out with regard to the necessity of allowing access to law enforcement to cover the whole property, everything within the property itself, because there's enough evidence to suggest that there may be multiple areas where evidence could support that crime or criminal behavior committed by those people or the defendants. So for the most part, it's very, very small in scope. All right, slide 12. So executing a search warrant. There are some general rules that must be followed in the execution of a search warrant. Search warrants must be executed in a timely manner to prevent information that establishes probable cause to be diminished. So when the judge signs off a search warrant, they're not going to allow a 2 or 3 week period of time between the signing of that warrant and the execution of the search to happen, because again, things change. The criminal aspect of that location may be lost because everything may be moved from one location to the next, and then the right to search there could be lost as well. Even if they do find other evidence, the evidence that they were looking for would basically be gone. The scope of law enforcement activities during the search must be limited by the warrant. And again, when we talked about warrants, they're very, very specific with regard to what can be searched and seized. Generally, search warrants must be executed at a reasonable time of day. However, exceptions may be authorized by the court. And right now, they're looking at the no-knock warrants, which have been ruled to be constitutional. There's a lot of departments that are looking at no-knock warrants now to as a result of some of the recent protests that have been going on. Law enforcement officers are generally required to notify the occupants of a residence that they're present by knocking at a door and announcing their presence, authority, and purpose before entering the premises to execute the warrant. Law enforcement may remain on premises only as long as it's reasonably necessary to conduct the search and to seize the items, and law enforcement must only use reasonable and necessary amount of force when conducting a search, such as breaking down the door to gain entry to the residence. Evidence seized during the execution of the warrant must be secured in a manner that preserves the chain of custody. So you'll see that term again. Chain of custody is a chronological documentation of the seizure, control, transfer, analysis, and disposition of that evidence. And the reason why they need to have that chain of custody is because the defense could utilize the fact that if law enforcement doesn't maintain a chain of custody, they can introduce doubt that the evidence that was collected is in fact untainted and still germane to the case. So if we have a bloody shirt, for instance, and a number of people got it and they were doing analysis on it and they were taking photographs, but we don't know who it was, the defense could introduce doubt into the presentation of that evidence, saying that, well, we have a person that may have had a cut on their hands and might have bled on it, and so now we have contaminated DNA evidence, or it could be a number of things. So that would be a measure of doubt that could be introduced into that evidence. Even if that evidence is solid evidence, a chain of custody is required to show how that evidence from the point of collection all the way to the point of introduction into the trial was maintained. Right? And there's specific mechanisms for securing evidence by law enforcement, forensic mechanisms to ensure that the evidence remains valid and usable versus one of the biggest things would be like a bloody piece of clothing. You're generally not going to take a bloody piece of clothing and put it in a plastic bag. And the reason why you don't put them in plastic bags is because blood obviously is liquid, and it can grow organisms, it can get bacteria, and actually eventually contaminate the evidence. So what normally happens with bloody clothing is it's laid out and dried and then bagged in a brown paper bag in a well-ventilated area, so that way it does not get mold or mildew and still remains viable as evidence. Okay, so the next two slides are dealing with exceptions to warrant requests and some of the exceptions to requesting the warrant. Abandoned property, and it goes through the different types of warrants that are being requested. Abandoned property, administrative searches, aerial searches, border searches, consent, inventory, motor vehicle, searches incident to lawful arrest, searches of open fields, plain view, special needs searches in public schools, searches of public employers and or their workspaces, searches of people under correctional supervision, and third-party disclosure. So I would suggest looking over these cases, making yourself familiar with some of them. Again, I made mention of the ones that you're going to really need to focus on for the purposes of the examination. However, just be advised that some of the cases that they're going over with regard to warrant request, I may not be asking you specifically about the actual case, but I may have case verbiage in the question, which would make you have to know, at least the basis of what that case is about. So please make yourself aware of these cases. All right, electronic surveillance is governed primarily by Title III of the Omnibus Crime Control and Safe Streets Act of 1968. This provides greater privacy protections than the Fourth Amendment by limiting who may apply for wiretaps, requiring multiple levels of administrative and judicial review, mandating wiretap procedures to minimize intersection of communications not subject to the wiretap order, require law enforcement to maintain confidentiality of what they hear and learn by intercepted communications, and requiring all recordings pursuant to the order be sealed upon the expiration of the order. So very, very specific with regard to electronic surveillance. And now a lot of those rulings have become even more kind of complex only because of the introduction of the internet. So Title III excludes regulating consent surveillance, which is when one party consents to the intersection of the communication, and this allows law enforcement to use the confidential informants by placing a microphone on them and eavesdropping on the conversation they conduct with others. Information electronically stored, such as emails and computer files, require a warrant supported by probable cause. However, Title III does not cover video surveillance, where the cameras only record images and not sound, which is pretty interesting. So if you have video of people walking in and breaking your windows and everything, a lot of people have video cameras of their homes. I do myself. Those video cameras, people can be recorded, and that evidence can be used. Now, unless that person is advised that they're actually being vocally recorded in concert with that video, that evidence, if it's secured illegally, then it would not be admissible. So there has to be an admonishment. People have to know that they are in fact being recorded, video as well as audio. Okay. All right. The next 4 slides talk about key developments in search and seizure law. Ones that you'll need to be aware of, obviously the Fourth Amendment, Mapp v. Ohio, and let's see, Tennessee v. Gardner. And those are the ones that I can see so far that I would probably really focus on for your exam. Now, just FYI, like I said before, many of these court cases, I may not be asking you specifically what the case is, but I may have the finding verbiage in there and asking specifically about what the Supreme Court found. So, I may be talking about, the idea of a person being detained and, being questioned, and do they have the right, are they in fact under arrest when they are being detained and don't have the right to actually leave, or feel like they have the right to leave of their own volition, and that belief would amount to arrest in the eyes of the law. So you'll need to know where that court case comes from, obviously, because you need to know where that ruling originated at. Okay. And then again, this is the last of the disclosing and suppressing evidence. And then the last slide 20, exclusionary rule in court and its costs. So pretrial motions, you'll see this again, are motions or requests that are made before the actual trial. So again, pretrial motions, these are requests made before the actual trial. One of these motions is a suppression motion, which is the request to the court that prohibits specific statements, documents, or objects from being introduced as evidence in a trial. These are usually introduced by the defense and are normally done because there's a belief that the evidence was illegally obtained. In one area, the burden of proof that the evidence is seized illegally is obtained, and it's borne by the defense. So unlike more often than, unlike most issues with regard to evidence, the burden of proof that normally falls on the prosecution now falls on the defense if their contention is that the evidence is illegal or was illegally obtained, and in order for that evidence to be suppressed. The decision on suppression motion falls to the bench or to the judge. So in the case of making a evidence, a suppression of evidence, that request has to be borne, or the burden has to be borne by the defense and not the prosecution. Police testimony is considered testimony by an expert witness during a trial. Testimony collected by law enforcement during an interrogation follows a two-pronged approach. You'll see this again. Law enforcement uses negative incentives such as advising the suspect of repercussions of lying, and positive incentives such as the benefits of confessing. For lack of a better term, you can say good cop, bad cop. Essentially, what they're trying to do is get people to understand that if they cooperate, that cooperation, that information is passed on to the court, and as a result of that, they'll likely be culpable of the crime, but their sentence would be reduced, or could be reduced, because of their admission early on in the process. Some circumstances, the exclusionary rule can lead to the freeing of guilty defendants during the trial, and even during pretrial proceedings. That does happen. So just understand that when we're talking about the exclusionary rule, it can move all the way through these pretrial motions where essentially we can have a dismissal of charges as a result of the exclusion of evidence if, again, like I said, the burden of proof falls on the defense. If the defense proves that the evidence that the prosecution wants to submit is tainted in one way, shape, or form, and the prosecution was the basis of their case was on this evidence that they wanted to submit. So this concludes Chapter 11. If you have, and again, if you have any questions, issues, comments, or concerns, please send me an email, call, or text. I'll be happy to take them. Thank you so much, and we will see you again on Chapter 12. Bye-bye now.